All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. We're here for oral argument in case number 1 CACV 17-0153, Thomas H. Strong Jr., petitioner appellee versus Stephanie Denise Owens, respondent appellant. Counsel, I'll remind you that this oral argument is being recorded, so please identify yourselves and your client at the beginning of your arguments. You'll each have 20 minutes. So appellant's counsel, please watch the clock and reserve as much time as you'd like for rebuttal. And keep in mind that have read the briefs and conference case this morning in our conference. So with that, counsel, you may proceed.
Thank you. May it please the court. I'm Sandra Slayton. I'm here representing the appellant mother. Stephanie Owens is sitting behind us, and I am also being assisted by my associate, Matthew Monaho. This case, more than anything else, I think, is about due process, and I'd like to start with the notice issue. A court puts out a minute entry and says that a hearing is going to take place on its own motion, not because of anything that the other side filed, but on its own motion. And it has specific language in that order. And one of the things is that both counsels shall try to resolve the issues. And then we come for the status conference, and the judge said, and we give our position on this lodge decree that hasn't been signed, and the trial judge says, never mind, that was an error. I'm so sorry. And it was just put out by the clerk. It was boilerplate. But that wasn't put out by the clerk, Your Honors. That was a specific minute entry from that division. It wasn't just some order from the clerk's office. It was from the trial court's own division, and it said, upon the court's own motion. That's a public order that everyone has a right to rely on. That order wasn't rescinded until literally 21 days or so after that status conference happened.
What was the harm to Ms. Owens as a result?
Well, the harm, first of all, her due process was violated. So I think the harm is presumed when you have a violation like that. But the second harm was that we made actual objections to that decree that hadn't been yet signed.
These were new objections. What new objections? Because your objections had already been raised once, the objections, and in the motion to set aside the Rule 69 agreement. What additional arguments would have been, or objections would have been made?
We did make them, and they were, I think the most important one was, or one of the most important ones, was the fact that there had been domestic violence, and that this was not in, that domestic violence happened following the February 22nd Rule 69 agreement.
So because there was not that hearing, then your position is that your client was precluded from presenting that argument?
That's right.
And presenting evidence?
Yes, we asked for an evidentiary hearing on that, on the that irregularity and the fact that the there was a clause in the final decree about the parenting coordinator that
when did you ask for an evidentiary hearing?
We asked. I don't have the transcript in front of me, but I believe we quoted to it, and we said that the court has to make an independent evidentiary finding, and we asked the court to hear evidence on the motion on the domestic violence that had occurred.
That was after the second?
That was at the December 8th hearing, Your Honor.
Okay, so that was after the time for after the second decree had been submitted and the time to object had lapsed.
And literally, it lapsed 1 day before the court. In other words, the time to object hadn't lapsed when the court itself filed its minute entry saying we're setting this for a status conference. And if you look at the language of Rule 81(2)(c), it literally says that, after 5 days, the court will enter, if no objections are heard, the court will enter the decree unless otherwise ordered or unless otherwise instructed to appear. Oral argument is optional, of course, but when a court issues a minute entry on its own motion and says we're going to have a status conference for this, and we showed up at that status conference and we gave our positions as to why that final decree shouldn't have been entered, that really was an implicit oral argument. And we asked the court at that time, we said, just give us, I'm brand new counsel. I had only been retained 2 days prior to that. Not that that really affects the due process issue, but it's just background information. And I said, give me 48 hours. That's all, even 48 hours to lodge objections. Even when the court gives counsel excusable, under the excusable neglect standard, that would be a reasonable amount to ask for. And we gave the court reasons. The next issue that really
What was the court's response? Remind me, please.
I'll think about it. And 4 hours later, she signed the decree. I literally stood there and begged her for 48 hours to do it. I said, even a day. Because as soon as we went into the courtroom, if you read the transcript, the court's position was, I'm sorry, you had time to object, you didn't object, and, oh, well, my minute entry was in error, and I'm rescinding it. You can't rescind a minute entry after the fact. When you've ordered somebody to be in court and they rely on that. And I have to tell you, and this is in our brief, I had only been on the case for 2 days, and I read that minute entry, and I actually, as a practitioner who's been around for 38 years, I actually believed it. And I took action on it. I called opposing counsel, and I said, Ms. Levy, the court has ordered us to confer to try to resolve any disputes before we go to the status conference. And the response was, I'm not going to talk to you about that. This was a mistake, and I don't think it was meant to happen. And I said,
was that said prior to the court rescinding the order?
Yes.
So opposing counsel recognized when he or she saw that minute entry that it likely was a mistake?
I can't say. I can just say what the conversation was. She said, I'm not going to talk to you. We're going to go to court, and you'll see that the judge is not going to uphold this. And that was like 2 days before the hearing. And then I got to court, and I said, we're here for this status conference, Your Honor, and we have real problems with this decree, and you shouldn't sign it. And, you have to keep it, and the court just wouldn't hear anything about it. Now, tying into that is the issue of the domestic violence and the fact that in the appellee's brief and in the trial court, their position was, oh, well, the domestic violence, and the trial court said, the domestic violence was never really before me. But this court in Marvin Johnson v. Myers specifically held there's one superior court. And the court absolutely knew about the order of protection. In fact, on September 29th, the court said, Mother's then attorney stood up and said, there's an issue that we need to bring to your attention, the order of protection. Now, we can't, I'm only limited scope attorney or whatever, however she put it, but this has to be dealt with, and we'd ask for it to be continued. It's an important issue. And the judge said, well, yeah, I know about it, and in fact, Judge Miller, the court that heard the domestic violence, said this has to go back to Judge Sloboda to see whether the minor child should have any contact with the mother. Now,
Isn't it true that the court,
I mean the father, excuse
and
me.
I may be recalling this part not as clearly as I'd like, but didn't the Superior Court start to talk about the issue of the order of protection, and Mother's Counsel said, we're not ready to talk about that right now. I'm not the attorney representing her on that, and actually precluded and prevented the court from addressing that issue?
I read that language too, and you could read it like that, but I think the more realistic reading of it is, the counsel said, this needs to be continued. This needs to be addressed by this court.
But didn't re-raise it later?
But I raised it. And under Hayes v. Gama, we're talking about the best interest of the child here. And keep in mind, there is no signed decree. As of December 8th, when I appeared before that court, there had been no signed decree. So nothing, and in fact, I found when I was preparing for this, and I didn't talk about it in my brief, but it's in the record, I bring the court's attention to IR 127. It was filed by father on November 2nd, 2016, and the first paragraph of father's expedited request for telephonic conference to confirm petitioner father's parenting time rights, which I don't believe occurred, but I might not have been privy to it since I wasn't counsel then. It says, and I quote, this is father, the final decree of dissolution has not yet been entered. Despite the recent orders of the court, the parties have not yet been able to finalize the terms of the final settlement documents. So
what was the date of that?
That was November 2nd. So, and keep in mind that I appeared December 8th and that the final decree hadn't been signed yet. And they admitted that we hadn't been able to agree on the final terms. And
Of the Amex points?
They just said it as, I'm literally quoting it, word by word. Despite the recent orders, the parties have not yet been able to finalize the terms of the final settlement documents. So even they said that the terms weren't finalized. And it just can't be the law that a minute entry is put out and published and a person shows up. I don't care how seemingly obvious it is to the other side, but to my client, who had been representing herself pro per from November 18th through the date of my appearance, and even to me, an experienced lawyer, the language had to be acknowledged of that order.
Assuming for a moment that the trial court was being truthful when it said that this minute entry was issued in error by the clerk, then is it your position that, error or not, the court then was forced to go forward with an evidentiary hearing?
I think at the very minimum, the court would say at that time, but I recognize, counsel, it is the way it could have gone. I recognize, counsel, that you didn't know that until today, and you're here, and I'm just telling you that now. And so I will give you time, additional time, to file objections to the lodge decree.
But that time had already passed. I mean, I realize you had just come on board, but the case had been going on for a while.
It wasn't it wasn't a jurisdictional issue. It's not like a notice of appeal had been filed and you just couldn't do it.
What you're saying is the court's error in issuing that minute entry that you read a different way than opposing counsel, apparently, should have allowed, in fairness, a reopening of the proceeding.
Yes, at least, very minimally, at the very least, giving us time to voice our objections, which I went in there and told her my many objections. And so the fact that there was another previous lodge decree, the fact that they're saying that we had all of these opportunities, there was no final decree yet. It's not.
Is it a plausible understanding of the record that you presented your objections to her, and later that day she signs the decree implicitly overruling all your objections?
She didn't. She signed the decree. And she then retroactively, 21 days later, rescinded that minute entry. I mean, even if...
Well, but I'm not that concerned about the erroneous language is operative and then it's eventually rescinded. I'm thinking about what you were able to present or not present. She didn't say, I'm not, correct me if I'm wrong, she didn't say, I'm not going to listen to you. You got to present at least a summary of your objection.
She said that there had been, I never went into detail about the order of protection. And I specifically asked her for an opportunity to do that. But at the hearing, she said, no, I'm not going to listen to any of this. The time has passed. And then, when, you see what I'm saying?
I do now a little better. Thank you.
Okay. And I would like to save the rest of my time, 4 hours and 24 minutes and 23 seconds.
No, we'll give you 4 hours.
It's going to be a long day. For a reply, if I may, if there's no more questions.
Yes.
Okay. Thank you.
Morning. My name is Mike Sherrick. I represent the appellee Thomas Strong. With me at council table is Dana Levy, my colleague who tried the case before the family court, as well as Michelle Kazi. I think that the appeal, rather than due process, actually focuses on the binding effect of a Rule 69 agreement. And that's where all of our discussion has to be premised. Is this a valid Rule 69 agreement? Then we follow on with the subsequent attacks on that agreement and whether they were properly made, properly preserved. So what do we have? We've got an agreement that was entered on the record in open court by parties represented by counsel. In fact, Ms. Owens was represented by Mr. Berkshire, who just appeared before this court in the previous argument. Those parties testified under oath. They understood the agreement. They stated it was fair and equitable. They stated it was in the child's best interest. And they stated that they entered into the agreement voluntarily. Pursuant to Rule 69, the agreement is deemed to be valid and binding. That's in the rule. And the family court here didn't abuse her discretion in rejecting.
With
Yes.
one additional requirement. Under Sharp, the court is obligated to independently find that the agreement was fair and equitable. What I'm struggling with a bit is I don't see that jumping off the page of any minute entry or any transcript, or I don't see it jumping off the pages of your answering brief. And I'd like you to explain what's your best argument for how the court complied with that obligation. Again, it's an independent duty. It doesn't matter what the parties say. I mean, that might be a factor that supports the court's conclusion, but the court has the independent obligation to make that finding in every Rule 69 agreement. My question is, did that happen here? And if so, what findings and or evidence can we glean from the record to affirm?
Well, I'm not sure that Sharp extends to the point where we would have reversible error in this case. We have, and I suppose your question also goes to, well, what issue is not fair and equitable? Is it everything? In this case, we did have temporary orders. We had a hearing on temporary orders. Child support and spousal maintenance was ordered then. At the trial, before the trial, in the court's preliminary statements, the court said, I'm going to consider the facts that I adduced at the temporary orders hearing. Then the parties adjourned and negotiated for almost 2 hours and came back with the Rule 69 agreement. They did come to the court and they said, we think this is fair and equitable. Is that binding on the court? No. Is that something that the court may consider and rely upon? Yes, and that's there's a case that that's Lothar versus Hooker. This case is more like it's an unpublished decision from April of 2017, Tauscher versus Hanshaw. And the reason I think I can cite it, at least for instructive purposes, is there's not a lot of published opinions out there to give us some guidance here. And in that case, the court concluded a sharp hearing was not required. And why was that? Well, the court in Tauscher versus Hanshaw said both parties met with counsel to negotiate a settlement. They did negotiate an agreement. They presented it to the family court. They then testified under oath that they're familiar with and understood the agreement, and they testified they entered into the agreement freely without coercion or duress. So there the court said, we don't need an evidentiary hearing. Frankly, that's what I thought the issue was presented by appellant in this case, is we should have had a sharp hearing. No, we didn't have sharp findings. I think those findings were made, and the record does support those findings with substantial evidence. I would commend to the court, I hate to do this because you've got a busy calendar, but there are several substantive reasoned minute entries in this case. It seemed like the court went above and beyond in some of her rulings to explain her thought process and what she was doing and why she was doing it. We also have transcripts of the original, the Rule 69 hearing. We have the transcript in December that really give you some insight to what happened in this case. And I don't think due process was denied here. Let's. Thank you. If I could go to the due process argument on the status conference, because my opponent feels that's the driving issue here. It was a status conference. I'm looking at the minute order right now. Is ordered setting a status conference on the second notice of lodging form of decree of dissolution. Now, you get that order, whether you're new counsel or not, you're charged with the history of what went on in the case. There's no trial set in this case. Yes, there is pretrial conference language in the minute order that says the parties are to meet and confer with respecting a number of matters with respect to a trial. The word trial is used 3 times. In any event, I fail to understand how a party can be denied due process in a hearing where there is no scheduled adjudication of any issue. The only matter that was pending was the second lodge decree, and the only issue that remained unresolved was the Amex points, which the parties had previously been instructed by the court to go resolve. They tried, and wife's prior counsel, after Mr. Berkshire, Ms. Harding, I believe, never came to the table on the Amex points.
Did that minute entry that had the language about the trial preparation, did it include the description of the Amex points? Was that referred to in that minute entry?
Not in that
recall?
Not
it
in
was
that
not.
one. Yeah, it was in a previous one, I believe.
Okay.
Let's keep the timing of what happened here. Again, I'm willing to delve into an issue that I didn't think was the driving issue in this appeal, but apparently it is. The second decree was lodged on November 10, 2016. The court's minute entry order was issued by the clerk on November 17th. All it says is status conference and then this pretrial conference language, which is quizzical. You stop. And as Ms. Slayton acknowledged, Ms. Levy said that's just wrong when they conferred about it. The response to or objections to the second lodge decree were due on Monday, November 21, 2016. Wife's prior counsel, Ms. Harding, was not ordered to or permitted to withdraw until November 23. So Ms. Owens was never pro per in this case, certainly not at the relevant time period here. She always had counsel. My personal experience is I moved to withdraw. I'm still a lawyer. I'm still counsel of record. I still have responsibilities to my client till the court says I'm out. But no objection to the second decree was filed. The status conference was set for December 1, but at Ms. Slayton's request and with agreement from Ms. Levy, that was postponed, and with approval of the court, that was postponed to December 8th. What's important here is, I was just looking at Rule 81. And this is a comment that Judge Svoboda made during the December 8th hearing. Even though she's new, there's no asterisk. She said there's no asterisk on Rule 81 for the deadline to file a response. And the court certainly, nowhere has the court ever said in this case your obligation to file a response, or objections rather, to the decree, the lodge decree, was waived. In fact, Rule 81C1 says the 5-day provision for objecting may be waived by the court only upon an express written finding by minute order or otherwise of necessity to shorten time or to enter judgment without notice. Certainly that didn't happen here, and I don't think any prudent practitioner should assume that they're not obliged to follow the rules, particularly in a case like this where the final decree, entry of the final decree of dissolution is pending, and there's only one issue to be resolved. As to the order of protection, again, we need to go into the history of this case a little bit. The parties stipulated to joint legal decision-making in the Rule 69 agreement back in February. Okay. Now, you could say, well, wait a minute, Mr. Sherrick, there's no order of protection in existence. No, but there is a valid and binding Rule 69 agreement that if there are changed circumstances down the road, I would submit that it's the burden of Ms. Owens to come forward with a petition to modify that under Rule 91 to change in light of the new order of protection. And so that's where we start. And that was never done in this case. And that, again, Judge Svoboda, at least 2 times in her reasoned minute entries, went through the history of the case and what was brought to her attention and what wasn't brought to her attention. Just so I understand you correctly, so the Rule 69 agreement, at the time this allegation was brought forward of domestic violence, or I mean, the order of protection was obtained. Yes. The court had already accepted, if you will, the Rule 69 agreement. Yes. And that was part of the record. It was. And there was a minute entry. Yeah, that's the minute entry that the court found to be equitable. I mean, fair, at least in the best interest of the children, and equitable, I believe, was the quote, what the court said there. That was. But that had occurred, and then there was the allegation of, or the order of protection was obtained. And your point was, if that was a cause or a new evidence, then there should have been a motion, an appropriate motion to set aside the Rule 69 agreement, or whatever you call it. I mean, to modify the joint legal decision making. And there's a special rule for doing that, Rule 91, and a special statute, ARS 25-411, and that just was ignored here. Then, now, the issue about Hayes versus Gama, Hayes versus Gama, it's just not a posit here, and here's why. In this case, at the time Ms. Slayton was coming to the court with her oral objections, which I submit had been waived, oral objections to the second lodge decree, the amended order of protection in place that went into place on November, I think it was November 29, doesn't involve the child. Hayes versus Gama is concerned about the best interest of the child and says you need to give those issues consideration. The order of protection didn't relate to the child, Trey. That the previous order of protection in the same case number, that fell away as to Trey, the child, on November 29th. So Hayes doesn't apply.
Can we discuss the issue of the parenting time coordinator?
Yes.
We have the issue of Exhibit 3, which Mother's Council submits. It is the consent order regarding joint legal decision-making and parenting time. Therein, offering that Michael McVeigh be appointed as the parenting coordinator via separate minute entry. There are some not related corrections made in Exhibit 4 from Father's Council. But then we have the issue of Rule 74, which went into effect January 1st, 2016, and requires 6 specific items to be complied with, and don't appear to have been in this case.
They were not, Your Honor. That's my obligation of candor to the court.
So how do we handle that?
Here's how you answer it, Your Honor. The issue's either moot or it's premature because the party stipulation and the decree said that the parenting coordinator issue would be handled by separate minute entry, and no separate minute entry was entered by Judge Svoboda. So it's just, it never got done. But I don't think it's before the court because today we don't have a parenting coordinator. So whether Ms. Slayton is right or the issue is moot or it's not ripe for consideration, I don't think it needs to be adjudicated today. Here's what happened. Here's what likely happened. The parties agreed to a parenting coordinator in concept. They agreed under the previous version of the rule. The rule changed with the 6 factors and the specifics. Rule 74 changed effective January 1, and council didn't attend to those 6 factors and put it in the decree, or the parenting order that would be part of the decree.
So remind me, the decree itself does appoint Mr. McVeigh?
I think it's a separate. It's in the decree or the separate custody order.
So
relates to Mr.
But he is appointed.
He's appointed, but the terms of his appointment were to be pursuant to a separate minute order entered by the family court, and that was never done.
That didn't happen.
Yeah.
Now, thinking that through
Yeah.
and looking at Rule 74, if I can put my hand on it, it requires that both parents agree. And the court can't simply issue the minute order or separate minute entry forcing the parties to agree if they don't agree.
Correct, Your Honor.
So then where does that put us?
Without a parenting coordinator. My colleague did point out, returning to Judge Brown's question about the independent determination under Sharp, the judge in the minute entry that it was ordered following the Rule 69 hearing on February 22nd says the court accepts the parties' agreement having found that the parties knowingly, intelligently, and voluntarily entered into said agreement and that it is in the best interest of the parties' minor children and is equitable. So the finding was made based, I would suggest, based primarily on the parties' agreement, which, given this case and the facts presented to the court at the time in February, the court, there was substantial evidence to support that conclusion. I really think I've covered the issues for the court. If you have any further questions.
No.
Thank you.
Thank you.
Your Honor, I'm just baffled. There is a parenting coordinator term in the final decree that was signed, and opposing counsel says it's not ripe for this court's consideration. That just can't
Well,
be.
counsel, do we or do we not have an active parenting coordinator in the case?
It could happen at any moment. I mean, father could go into court and say, I have a judgment and I want to enforce it, and we're going to appoint, and it's in the decree that there is a parenting coordinator, and it's going to be enforced. And the fact that they haven't done it yet is quite beside the point. This is a final decree.
Maybe the parties could stipulate right now that it be stricken and to be dealt with later upon request if anybody ever requests it.
But that's just one of the many irregularities in this decree. The other irregularity in the decree, which wasn't even mentioned, is the term that the sentence that there are no orders of protection existing in this case. That finding was made and signed when the court knew very well, and it's undisputed, that there was an order of protection. And 25403.03 says that the court has an independent duty to see whether this is a rebuttable presumption that can be overcome. And 25403 says that it is absolutely not in the child's best interest for joint custody when there is domestic violence. So the only question is, was there significant domestic violence? And that's where my argument that this court should take notice of the order of protection and the contents therein. The Scottsdale Memorial case that this court mentioned in its previous order was a case where the same parties weren't at that other proceeding. But not only were the same parties at this order of protection hearing, but the same counsel, Ms. Levy, was at that hearing. And it is simply indisputable, and the court has the transcript. The court doesn't have to make conclusions about it because the order of protection judge made the conclusions. It was so bad. There was a finding. Contrary to their brief, this wasn't just a finding, some harassment occurred, be good. This was a finding of domestic violence. That is in the order, and that is in the record. And not only was it
Finding of harassment under the domestic violence statute?
There was it said there's a finding of domestic violence. And not only was there a finding of domestic violence, and that yes, it was harassment, but it was also domestic violence. There was a threat. The judge said this is beyond the pale, and he felt so strongly about it that he entered a Brady order against the father. And you can only,
if the judge felt so strongly, why did it expire?
The judge said this will be heard. Judge Miller knew that the case was coming before Judge Sloboda.
Counsel, why didn't you file something under Rule 81 or 25411 saying there needs to be a reconsideration, because now, since the judgment, since the Rule 69 agreement, there's this new issue, rather than just bringing it up in argument, putting evidence before the court?
Well, Your Honor, I got retained. I read the docket. I found the order. And about 48 hours later, I was in front of Judge Sloboda. And that is exactly what I asked to do. I said, I need to act on this. I just got on the case. A decree hasn't been signed. Under Hayes v. Gama, you're on notice, Your Honor. This is a very important issue, and I'm not the first person that said it was an important issue. Even prior counsel said it. Was it done perfectly by prior counsel? I mean, was anything done perfectly in this case? I would say no. And I'm sorry, you wanted to say something.
No, just your time is up, so if you're, I'll give you 30 seconds.
I would just say you have to understand that this whole thing, the Sharp hearing, is a giant issue in this case, because mother literally said, I think it's fair with the caveat under the circumstances. And there were tremendous problems with that hearing. Thank you.
Okay, counsel, thank you both for your arguments this morning. The court will take this matter under advisement and issue a decision in due course. The court is now adjourned.
Thank you.